Ladies and gentlemen, thank you so much for being here with us this evening. If y'all could take your seats, please. We're about to get started. Well, thank you all so much for being here. My name is Emmeline Decker. I am a 2L here at Texas Law and this year's Symposium chair. It is an honor and a privilege to be the one to introduce you to our keynote speaker this evening. Governor Greg Abbott was born in Wichita Falls and raised in Duncanville, Texas. He graduated from the University of Texas here in Austin and earned his law degree from Vanderbilt University Law School. Shortly after law school, he was paralyzed by a falling tree while jogging. From his faith and family, he gained strength, recognizing our lives are not defined by our challenges, but by how we respond to them. Greg Abbott is the 48th governor of the state of Texas. Before his election in 2014, he was the 50th and longest-serving Attorney General of Texas. Governor Abbott also previously served as a justice on the Texas Supreme Court and as a state district judge in Harris County, Texas. Named Best Governor in the Nation in 2020, Governor Greg Abbott continues to build on his record as a strong conservative leader who fights to preserve Texas values and ensure the Lone Star State remains the best place to live, work, and raise a family. Would you please join me in welcoming Governor Greg Abbott?
Thank you very much. Appreciate you. Thank y'all very much. Thank y'all very much. Let me start out tonight with a couple of quick questions. One, I see some people in cowboy hats, and I got one of this. For those in cowboy hats, how many of you, is this the first time you've ever worn a cowboy hat? Just a couple. From Boston, right? Good to have you here. There you go, some finger pointing going on already. Second question, so I can get a feel. Man, I got some lights that make it hard to see. Please raise your hand if you are currently in a law school. Wow, fantastic. That's what I was looking for. Because I'm on a recruiting mission tonight. And I want to talk about what's going on in our world, more importantly, what's going on in our country, and kind of explain that to you through the lens of my legal career. And after the first 3 hours, we'll come back and just, actually it's going to take 15 minutes. But let me start on a serious note. The country is in a battle for the soul of the future of America as we speak. We have on one side the social justice warriors and anti-constitutionalists. On the other side, we have constitutionalists and people who believe in the rule of law. I happen to believe in the rule of law. That's why I went to law school. It's why the founders of our country, the authors of the United States Constitution, instilled the rule of law into our Constitution to begin with because they wanted to create a different type of country than had existed before that time. A country that was based upon the rule of law, not the rule of man. And that fledgling country they created has gone on to be the most successful country in the history of the entire world. And I submit to you that a principal reason for that success, a principle that causes America to stand apart from all other countries, is our Constitution and our adamant insistence on the rule of law. At the same time, the reason why we're in a battle right now is because of these social justice warriors and the anti-constitutionalists, people who are against the rule of law, people who take official positions, elected positions, to undermine the rule of law. And if they succeed, I believe it will destroy our country as it is. The deal is that there are two categories of people involved in this battle. There are people who are on the field and people who are on the sidelines. Only two positions. You're either in the game or you're on the sidelines. I believe mathematically, those who believe in the rule of law are outnumbered. The other team has more people on the field. We need more people who believe in the rule of law, more people who believe in the Constitution, on the field engaged in that battle. I believe we're still winning the battle because we're on the side of the righteousness. But if we come up short in numbers, who knows what may happen? And I want to, as I told you earlier, quickly guide you through my career and show you that during the course of your careers, even now when you're in law school, you have plenty of on-ramps to get into the battle. Just as I needed a ramp to get on this stage tonight, to be able to talk to you about the fights that I've been involved in, you will have plenty of opportunities to have an on-ramp to get into this battle that we need you in if we're going to win this fight for the soul of America. For me, it began when I was in law school. When I was in law school reading constitutional law, I was amazed and concerned when I saw opinion after opinion after opinion that seemed to rewrite the Constitution, skirted around the words of the Constitution, made up new law. And I knew that that was no way of ongoing existence because we would soon become the rule of men, whoever was interpreting and applying the law. Quick pop quiz question. You can just shout out the answer. How many votes does it take to change the Constitution? Yeah, I got three-fourths. I want to say who said what. Some people were saying 3/4, some people say 2/3. Whoever said 5 has it right. It takes exactly 5 votes to change the Constitution, and I'll make a point about that later on. But I learned that back when I was in law school. And I knew when I left law school, I wanted to be engaged in this fight for the rule of law. The problem is things changed for me after I left law school. After I graduated from Vanderbilt, in fact, when I graduated from Vanderbilt, when I got my diploma, was the last picture of me standing. I left and I moved to Houston with my wife where I had taken a job with a large law firm. And I was studying for the bar exam, 10 days away from taking the bar exam. And I wanted to take a break and went out for a jog. And while I was out jogging, a huge oak tree, taller than the ceiling in this room, crashed down onto my back, fracturing my vertebrae and my spinal cord, leaving me immediately paralyzed for the rest of my life, altering the arc of my life. Some of you are thinking, man, I don't want to have to use that as an excuse for missing the bar exam. But it set me back a year in my career because I had to go through a year of hospitalization and rehabilitation. But I eventually was able to go to work, and when I went to work, I had to kind of feel my way forward at a time long before the Americans with Disabilities Act was even in place, navigating different challenges. In fact, when I went to take the bar exam a year later, a year after my accident, so my accident was in July of 1984, I took the bar exam in July of 1985. Before the ADA, my wife dropped me off at the convention center in downtown Houston, Texas. And for me to get into the convention center, I had to hop a curb. And when I hopped the curb, I had to do this. Just a little wheelie, then my wife would lift up the rest of the chair. On this particular day, with me going into the convention center, with the bar exam beginning in 15 minutes, when I lifted up my wheelchair, the front wheel came off. And we had no idea how to get back on. Somehow, some way, in 5 minutes, we got that wheel back on, got me in there, and I was able to take the exam. I was rocked a little bit more because as we were taking it at that time, they were like these cafeteria-style long tables. One person there, I was here, one person there. And we were in the middle of taking the exam, and the one person who was there, in the middle of the exam, the proctor came up and grabbed their book and escorted them out. Thinking, man, something's amiss there, but you just got to keep your head down. And I will give you this hint. For those who will be taking the bar, it looks like the majority of the room who raised their hands, you'll be taking the bar one of these days, and the reality is you won't know the answers to all the questions. This is not an SAT. If you get every question right, you studied way too hard. But have some fun if you don't get it right. So I hear they may have changed the bar exam. Like when I took the bar exam, I got a question. The question was, what is a writ of capias? And I had no idea. So as opposed to just skipping it over, I thought I'd have fun with a grater. And I wrote down that it was a type of fish. And I may have gotten credit for it. Who knows? Well, I passed the bar exam and went to practice law. And for a person in a wheelchair at the time, I may have been the only person in Houston who was a litigator practicing law. And in my early days, the things that you do most often as a litigator is you show up to argue motions. And every Monday was motion day. You go to the courthouse and you have whatever motion for summary judgment, motion for whatever. And it starts at 9 a.m. And I got there about 5 minutes before 9 o'clock. And the bench was on that side of the room. And when I came in, every possible location was taken. And so what I did when I got to the room is I pulled up next to the jury box. The jury box was right here, extending from here back over there. And I sat right here at the end of the jury box and got there just in time before the bailiff comes in and says, "All rise." And everybody stands up. Judge comes in. Judge ascends to the bench. For those who may practice or have ever practiced in Houston, his name was Wyatt Hurd. So Judge Wyatt Hurd ascended the bench and gazed across the room and saw me about this high next to his jury box. And he looked at me and said, "Sir, when the bailiff says, 'all rise,' that means stand up." And so I wheeled out a little bit. I said, "Your Honor, I would if I could, but I can't." He turned beet red, and I won the motion that day. In fact, word spread so fast at the law firm, everyone, whoever had a motion in Wyatt Hurd's court said, "Let Abbott have it. Where is he going to win it?" But it got even more amazing because eventually you go from motions to trials. And I had a trial against a guy who was injured and hurt. And his lead argument was that he could not go to work because he was hurt. And because he was injured, he was testifying from the witness stand, and he had a cane with him, and he was explaining how he couldn't work. And I'll tell you this, for those who want to be litigators, this is a handy tool. There are some advantages to being in a wheelchair. One of which is, and again, this is the jury box, to cross-examine the person who was bringing this lawsuit. I pulled up next to the jury box as though I was sitting in the jury box with them. I wasn't presenting an argument to them. I was one of them. So my suggestion to you is, if ever you become a litigator, pull up a chair next to the jury box as you're cross-examining someone or making your closing argument to them, as opposed to standing over them telling them what to do. Be one of them and join with them. Anyway, I was cross-examining this guy with a cane, and I got to the point where he was claiming he couldn't work. And I was there by the jury box doing my work. And the irony was not lost on the jury. And the irony suddenly hit the guy who was bringing the lawsuit. No kidding. The guy got out of the witness box and came down and started beating my wheelchair with his cane. Case dismissed. It was over. Well, I went on to represent some individuals ranging all the way to some of the largest businesses in the United States. But along the way, and this is one of those on-ramps, along the way I got very frustrated. I spent a lot of time and a lot of my clients' money writing these motions, making sure every detail, every citation, all that kind of stuff was exactly right, only to go into courts and have a judge say, listen, I haven't read all this stuff. I know Donnie Joe over here, and Donnie Joe's a good guy, and I know what he's thinking is right, so I'm just going to go with him. So I have no idea the thousands of dollars in expenses I racked up on behalf of my client, only to have a judge make a decision like that on the basis of impulse, as opposed to the details that were written in to that motion. And I decided at that moment, I was going to do something about it. I was going to use that as an on-ramp to go back to what I told you my mission was earlier when I was in law school, and that was to find a way to ensure that the rule of law was going to be applied in our society. In Texas, we elect our judges. And I decided at that moment, by God, not only am I going to run for judge, I'm going to run for judge in that court against that judge. Well, that judge saw the handwriting on the wall and decided not to run. And not only did I run, but I won the election. Served there for 3 years. At the time, George W. Bush was governor of Texas. He appointed me to be a justice on the Texas Supreme Court, where I was elected and reelected before I was elected to be Attorney General. When I was Attorney General, what I needed to do was to assemble a team of outstanding lawyers to make sure that we would be able to have Texas be the standard bearer for the United States and showing what the rule of law is. So I brought in people I had never met before, but people with extraordinary talent and capability. For my Solicitor General, I brought in Ted Cruz, who I'd never met before, but he turned out to be pretty good. And as a special counsel, I brought in a guy named Donnie Rice. So most people who go by the name of Don, they're like Donald or something like their given name. This guy's first name by birth is Donnie. Donnie Ray Willett, Judge Willett, who I saw earlier in some smashing pants. Oh, there they are. And so Don and Ted and others guided me in the early days of my tenure as Attorney General, and we tried to do our best to just ensure that the rule of law was applied. Until one day, an atheist was walking across the Texas Capitol grounds, and the atheist saw the Ten Commandments and got offended. It sounds like the beginning of a joke with a punchline. It was actually the beginning of a lawsuit, which he filed against the state of Texas to have that Ten Commandments monument torn down. And I'll tell my team, not on our watch will we allow the Ten Commandments to be torn down on the Texas Capitol grounds. The case went all the way to the United States Supreme Court. And this gave me a different opportunity that I've been looking for. Go in your mind right now, if you want to be a litigator, the ultimate place you can ever go to litigate anything is the United States Supreme Court. You got to argue a case to the United States Supreme Court. And I had my chance in this consequential case on an extraordinarily important piece of First Amendment litigation. Anyway, we get to the court and get all ready for the argument, and only to realize when I arrive at the court, I'm not going to fit at the podium, which was a little bit taller than this podium. And so I had to argue from counsel table. On this particular day, at that time, the Chief Justice of the court was Chief Justice Rehnquist. He was absent that day because he was ill, but he still participated in the decision. But the presiding judge was Justice Stevens. And he told me to argue from the table, which I did, argue the case. And at the conclusion of that, the presiding judge, Justice Stevens, said, he called me General Abbott because that's what Attorney General is called. General Abbott, this just goes to show you do not need to stand at a podium to make a good argument. But also just go to show, just because you get a compliment from a judge does not mean they're going to rule in your favor. It turned out that the whole premise of my argument was based upon Sandra Day O'Connor, who was the leading author at that particular time of the First Amendment freedom of religion principles that we were litigating. And it didn't matter who asked whatever question. I was going to respond with an answer that I thought appealed to Sandra Day O'Connor. Scalia asked a very predictable question, trying to pin me down that the reason why we were making this display of the Ten Commandments on the Texas Capitol grounds was to convey a religious reason. I said, absolutely not. And he said, if that's not why you're doing it, then I cannot be for you. And I'm thinking, the last person who's going to vote against the Ten Commandments is Scalia. So don't worry about that. And I still geared everything towards Sandra Day O'Connor. Anyway, the opinion came out at the end of June, like they typically do. And it turned out we won 5-4. We actually lost the vote of Sandra Day O'Connor. But for some reason, somehow, some way, we picked up the vote of Breyer. And as a result, those 10 commandments still stand on the Texas Capitol grounds today. And it was only after that there was a change in the presidency and a change in America and a change in a galvanizing and organizing of the social justice warriors that led to the anti-constitutionalists. And it came with the installation of Barack Obama as president. Because as we were just going about our business trying to enforce the rule of law, we found suddenly there was someone who was circumventing the rule of law. And that was none other than the President of the United States of America. And so much so that it led to a recharacterization of my office. And I would go out and tell people that as Attorney General, I wake up, go into the office, I sue Barack Obama, and I go home. I set an all-time record for the number of lawsuits filed against Barack Obama. So one of those involved Obamacare. Obamacare, doesn't matter where you stand on health care, Obamacare had one flaw. And it was the one thing that Obamacare needed in order for it to be effective, and that was the individual mandate. And that individual mandate was something that had never before happened in the history of the country. Congress relied on the Commerce Clause to say that health care was commerce, and they could impose this mandate. However, in the history of the entire country, even though Congress and courts had continuously expanded the scope and meaning of the Commerce Clause, never had it been construed so broadly as to apply it to someone who refused to engage in commerce. If you engage in commerce, then they can regulate it. But if you abstain from commerce, Congress does not have the authority to regulate you or your behavior. But that's what Congress did with the individual mandate, because it forced you into participating into the Obamacare healthcare program. We thought that was clearly unconstitutional. All the know-it-alls said we were fools for even thinking that. But Texas and 12 other states, we called ourselves the 13 original colonies of Obamacare, that eventually led to 26. So we had a majority of the United States suing the United States, seeking to overturn Obamacare. And obviously went to the Supreme Court and was decided, and we were there not just for the argument, but for when the decision was handed out. This decision, for one, the argument didn't last 1 hour, which they typically do. Didn't last 1 day. It lasted 3 days for the argument. And for the opinion, they read their opinion from the court, led by then Chief Justice Roberts. He started the opinion talking about how this was not a tax for purposes of the Anti-Tax Injunction Act. And then he gets to the heart of it. He gets to the Commerce Clause. And that is, he went through and he explained exactly what our position was. And that is that Congress, let's say the Constitution, Article 1, Section 8, does not authorize Congress to force somebody into the stream of commerce. And as a result, the Commerce Clause was not a valid reason for Congress to pass this law. Then we get to the argument about the necessary and proper clause. And the Chief Justice read that whether or not this was necessary, it was not proper. And then we get to one that we thought was the easiest of them all, and that is whether or not this was a tax. And the law itself clearly said that if you do not if you don't have health care, you'll be subject to a, quote, penalty. Penalty is the word that was used. But more important than that, Congress meant the word penalty, not tax, because Congress knew they did not have the votes to get it passed if it was a tax. And President Obama was clear in the way he sold it to America, this is not a tax. The point is this, the executive branch said that it was not a tax. The legislative branch said it was not a tax. Only one person said that it was a tax, and that was Chief Justice Roberts. And that was all it took to join with 4 other justices to uphold Obamacare. But in doing so, we were successful in doing what I wanted to achieve going back to my law school days, and that was to rein in the abuses that I saw taking place by the never-ending expansion of the Commerce Clause. So we go from there to me running for and getting elected to be governor of Texas, which happened in November 2014. And just a few weeks after the election, there was a nationally televised presentation by President Obama on November the 20th, 2014. During that presentation, he told America something that he'd been dealing with during his entire presidency. His entire presidency, his own party was nudging the president, pushing him, condemning him for doing nothing with regard to loosening the immigration laws of the United States. And he said that he couldn't do anything about it, was up to Congress. He said more than 20 times he didn't have the ability to do anything about it. Until on November the 20th of 2014, he announced he was taking executive action to grant amnesty to 5 million people who were in the country illegally. The president does not have the authority to make law. President Obama actually even said he made law by granting that amnesty. I knew that was wrong. I knew it was an abuse of executive authority. I knew it had to be stopped, but I was on my way out of office. I needed to do something about it urgently. 13 days later, I filed a lawsuit to put a stop to it. I was able to do it that quickly and that effectively because of the lead counsel who was in charge of it. One of the most brilliant people I've ever met. His name is Andy Oldham. He's now Judge Oldham on the 5th Court of Appeals. Thank you. Also, along the way, I omitted a name, not purposely, I forgot to bring it up. So when we filed that lawsuit, that Obamacare lawsuit, my Solicitor General at that time was Jim Ho, now Judge Ho, with the 5th Court of Appeals also. So I see him over there standing next to my current general counsel, James Sullivan. Looks like a murderer's row over there. So that's what you call legal talent right there. And so what I'm doing tonight, I'm trying to help you understand. We need legal talent like that to get in the game. People who can make a difference. That's exactly what they did. And I didn't finish the story about the court. In the case that Andy filed, we won in the trial court. It went all the way to the Supreme Court. Andy was then in my general counsel's office as governor at the time. But the Supreme Court ruled in favor of the lawsuit that we filed, upholding our position that the president had exceeded his executive powers. So once again, all of this relates to ways in which we must take action to ensure that all actors are going to conduct their affairs constitutionally. It's the rule of law. The only way that we will survive as a country is to ensure that rule of law is protected. The only way we will achieve that goal is to have people like those in the room tonight, as you move forward in your careers, in your pathways, you will keep in mind the necessity to have you not on the sidelines, but in the game. If you do that, I can assure you the United States will remain the mightiest, strongest, and best country in the history of the world. Thank you all. God bless you all, and God bless the great state of Texas. Take care. Sure.